Hello, everyone, and welcome to today's webinar, Government Enforcement Actions, How to Respond and How to Prepare, co-sponsored by Frier Levitt and PRI. My name is Katie Guglielmo, and I'll be your moderator. I'm the marketing coordinator of Frier Levitt, and I would like to introduce you to our speaker today, John E. Morrone, Esquire. He is the managing partner of our New York City office. Before we get started, I just wanted to note that all lines have been muted. Also, I want to remind you about the Questions tab on the right side of your screen. Go ahead and type in your questions throughout the webinar today. We will wait until the end of the presentation to answer those, but we'll be sure to get to all of them, whether it's during this live webinar or emails after this webinar. The webinar will be recorded and sent to you via email in the next 2 days. So, without any further ado, I'd like to kick things off by welcoming our managing partner, John Morrone. John, over to you.
Thank you, Katie, and welcome everyone to this webinar. Thank you for joining. And hopefully that this webinar doesn't scare you so much that you forget about the coronavirus. What we're going to be speaking about today are the various enforcement actions that the federal government can take against providers and what the current status is and the prospects for the future. So just a quick disclaimer that this webinar is for information only. It does not establish a attorney-client relationship, and any legal advice needs to be attained by retaining a qualified healthcare attorney. A little bit about Frier Levitt is that we're a boutique healthcare firm with over 30 attorneys who practice solely healthcare law, meaning that we are entirely focused in the healthcare space, representing clients from solo physician practices to publicly traded companies and every type of clinical discipline in between. We advocate for independent pharmacies, independent physicians, and a variety of other providers, and we provide a number of services to our clients that include both general corporate law type activities such as contracts, and we also do a great deal of defense work, both criminal and civil defense, as well as litigation and mediation with payers. So to just jump right in and kick things off, these are just a few of the enforcement actions that have come out literally over the past week and a half. Connecticut, $4.9 million False Claims Act settlement with a physician couple. Georgia Medicaid provider pays $1.75 million to resolve false claims. The Department of Justice filed suit against a device manufacturer and their executives for allegedly paying kickbacks to surgeons to use their devices. A medical biller was sentenced in a healthcare fraud scheme. 2 Connecticut physicians are paying $4.9 million to settle false claims. And even Big Pharma is not spared the wrath of the federal government, but Sanofi agrees to pay $11.8 million to resolve allegations that they paid kickbacks to patients through a sham copay assistance foundation. So this is just to kick everything off and show that enforcement actions by the federal government are really at an unprecedented level, and to proceed unabated through the future. So the relevant statutes that the typical healthcare provider hears about are the federal anti-kickback statute, the Stark Law, which is the prohibition on physicians making referrals to entities with which they have a financial relationship with, and the Federal False Claims Act. So the Federal False Claims Act is a statute that dates back literally to the Civil War, and it isn't isolated or limited to healthcare. It fundamentally requires that where a individual or entity makes a material misrepresentation in the presentment of a claim for payment to the federal government, that would constitute a false claim. So the reason that this began during the Civil War, the statute was meant for to stop manufacturers of war materials from selling defective or misbranded weapons to the federal government. So the False Claims Act, as I mentioned, it covers all sorts of fraud, not just healthcare. In the healthcare space, the types of acts that can constitute a false claim are extremely broad. Obviously, the most egregious one or most obvious one is where a claim form or an electronic claim is submitted to the federal government and there is a misrepresentation on that form. So, for example, an upcoded diagnosis, or another common fraudulent act is where one provider provided service, but the claim was billed under another provider's NPI number. Now, this is something that was really ubiquitous in healthcare. Medical practice would add a new physician, and while waiting for that new physician to get credentialed with the payers, that physician would provide care to patients, but the claim was billed under one of the other physicians in the group who was already credentialed. That is a clear false claim. Another type of false claim, which is a little bit more diffuse and a little bit deeper, is something called implied certification. And what that means is that when a claim is submitted to the federal government, the provider submitting the claim is making a representation that they are compliant with all applicable laws. And now this concept went all the way to the Supreme Court in a case called Escobar, and the Supreme Court upheld the federal government's ability to charge providers with false claims under this implied certification theory. So what would be an implied certification that would be problematic? Well, a claim is submitted to the federal government for payment, and the service was, and this was the case in Escobar, the service was provided by a non-licensee. Right? So in Escobar, it was a physical therapy practice, and the physical therapy aide that was performing the service was not licensed. So that's an example of an implied certification violation, is that it's implied when you submit a claim that you're complying with all applicable laws. Another one that's very obvious is that if there is an excluded provider, someone that's excluded from federal health care programs. And the list really goes on, and it can extend to things such as substandard care being provided, or upcoding, or a variety of other types of transgressions. So the implied certification theory gives the federal government very broad latitude to bring false claims actions. So the purpose of the False Claims Act from the federal government standpoint is to act as a deterrence, to seek restitution and recover money that has been paid out, and to punish the transgressors. And each of these functions is served in calculating damages and the damage structure, as well as So that's really the financial aspect of false claims. But there's also other actions that the government can take in their enforcement, including the exclusion from participation in federal health care programs. So many of the judgments that we see, particularly ones with large companies, have some pretty astronomical numbers. I mean, there are companies such as Johnson & Johnson and Omnicare have paid north of $2 billion in restitution to the federal government under false claims. And the way that it's calculated is that the government can seek treble damages, which means 3 times the amount that they paid out. So if a single claim is $1,000, the government can take back $3,000 plus a civil penalty for each claim that can range between $11,000 and $22,000. So that's for each claim. So you can see that on a single $1,000 false claim, the government can get almost $25,000, and that's how you get to these very high numbers in the billions. The other ramifications for violations is an exclusion from the Medicare provider list, or exclusion really from the federal provider list. And when an entity or an individual is excluded, fundamentally you can't do business with the federal government at all. Kind of the next level down is that there's what's called Medicare revocation, and that is less encompassing as the exclusion. That is a revocation by Medicare of providers' privileges. Usually, that when a revocation occurs, the provider is able to reapply, usually within a year or 2 years, to the Medicare program. There are other types of payer termination, state Medicaid, and also a trickle-down effect with commercial payers, that many commercial payers have in their contract that if a provider is terminated by Medicare or is on the excluded provider list, even though it's a commercial payer, they will terminate your payer contract. Also associated with False Claims Act is licensing board discipline. So very often licensing boards will pick up on government investigations. Sometimes the federal government, in the form of the DOJ or the Office of the Inspector General, will actually notify licensing boards of settlements and enforcement actions, and that leads to secondary independent investigations by the licensing boards. And just a side note on licensing boards is that we have seen in the past several years, the activities by licensing boards have also increased dramatically. Many licensing boards, we surmise, are looking at enforcement as a revenue source. We've seen fairly significant increases in fines, frankly dramatic increases for fairly de minimis transgressions. So, the discipline by licensing boards is not something to take lightly, and can ultimately, result in a provider's inability to earn a living or to bill anybody or provide their service by getting a disciplinary action on their license. And then the other thing, and we as a firm, we have a number of attorneys that handle disciplinary actions with boards across the country, is that it is really getting disciplinary action on your license really creates a host of other problems that, on virtually all future applications, whether that be for payers, for licensure in other jurisdictions, for medical staff privileges, the provider is then required to disclose the disciplinary action and explain it, and it really is something that follows the provider for the rest of their career. And then the third are tax considerations when there is a False Claims Act assessment. Although she has gone in dramatic fashion, the former Deputy Attorney General, Sally Yates, issued an edict to the Department of Justice that is still in force, which essentially says that where the Department of Justice is pursuing false claims liability against an entity, that in a closely held corporation, which most physician practices and physician groups are, that when the entity doesn't have the ability to pay, the enforcement action by DOJ, that the DOJ attorneys should go after the individual owners and shareholders or members of the closely held company or corporation, under the theory that in a closely held corporation, the shareholders and the entity are virtually one. So many folks think that they can hide behind the corporate shield as they can with normal liabilities. That's not the case when the federal government is the creditor. They can and do pursue the individuals. Another area that's related to the False Claims Act that one needs to be concerned about, which has also grown exponentially, is qui tam actions. Qui tam actions are frequently referred to as whistleblower. These are a little slightly different than whistleblower. It's basically an enforcement action taken by private citizens on behalf of the federal government. So an individual goes and gets a lawyer, that typically it's a disgruntled employee, and they say, well, I know that this hospital that I worked at did bad things and upcoded and falsified medical records and submitted claims for services that weren't really provided and changed doctor's notes and any one of a variety of different things. And that attorney, who's a private attorney, files suit on behalf of the federal government. That filing is kept under seal by the court, and then the federal government will evaluate the merits and either intervene, which means that they will take on the case and advance the interest of the federal government, or they will decline to intervene, at which point the private citizen can continue the litigation, or they can drop the litigation. The reason behind the qui tam laws is that it's the government using private citizens and using basically people within organizations to help with their enforcement and to incentivize individuals to come forward and basically disclose information about their current or former employers or partners or just things that they know about. They will get a percentage of the government's recovery, and in many cases, these are very significant awards. So we've seen, where a qui tam relator has gotten either tens or millions of dollars for initiating a qui tam action. So it's not hard to see that there's a tremendous incentive for people on the inside to pursue key TAM actions. So let's turn for a moment to one of the questions that I get asked all the time as a regulatory attorney is, well, how does the government find out? How do they know? Or how do they decide? And we at Frier Levitt, we have a government defense team that's comprised of white-collar criminal attorneys, regulatory attorneys, litigation attorneys, and that does a great deal of defense work with the Department of Justice. We probably have about 40 matters going on right now, some that have spanned a number of years. And when a client gets that subpoena or a civil investigative demand or gets the knock on the door by the two FBI agents, one of the questions that comes out is, why are they picking on me? How did they decide to come after me? How did they decide to come after my medical practice? Why are they looking at this company? Why are they looking at this hospital? And the answer to that is that it depends, is that the government uses a variety of different techniques to decide how to investigate. One of the things that we know, because we've been told this by a number of U.S. attorneys' offices, is that the Department of Justice and their attorneys are measured on a metric of their return on investment, or really their return on investigative dollars. So it's expected that for every dollar spent to investigate, that at least $8 is recovered in restitution from the investigation. So the government tends to pick claims or pick investigations that have a high likelihood of success. One of the other areas that the government uses is what are called heat zones, and there are designated areas throughout the country, certain cities, certain locations within a city like Brooklyn, New York, or Miami, Florida, that just have such a high incidence of healthcare fraud that they are targeted, and merely by being a provider in one of those areas, you may be subject to scrutiny. But very often, the government's investigation, or where there's smoke, is a little more precise than that. So, in the pharmacy space, for example, there is a list of indicia of fraud that the government will look at. And in this age of technology and the ability to do pretty precise data mining from claims data, from other sources, the government can look and expend really not a lot of resources to find out some of these factors that they view as indicia of fraud. Is a pharmacy in one state receiving prescriptions from a prescriber in another state, and what is the volume? Where, although that is not necessarily illegal, it's unlikely as to why that would be going on, or in the eyes of the government, that's not something that's that common. Now, if you haven't been able to tell by my accent, a native New Yorker, we have a significant population that exits the state of New York on December 26th every year and goes to Florida, as we refer to them as snowbirds. So it's very likely that you're going to have people with New York addresses filling prescriptions in Florida and vice versa. So that's an area where you'd say, well, there's nothing wrong with that. But where, a pharmacy is located in Michigan and is filling prescriptions in Hawaii and mailing them halfway around the world, that raises the level of suspicion on the part of the government. Prescriptions that are written on pre-printed prescription pads, or prior authorization forms that are pre-populated by either a pharmacy or the drug manufacturer. Prescriptions that are invalid on their face. When you have multiple prescriptions for the same patient that seem to be incongruent with the treatment that the patient has received. When you see patterns within a certain demographic. When you see a very high percentage of prescriptions coming from one source. When one prescriber is accounting for a disproportionate percentage of prescriptions going to a pharmacy. When there's a sudden spike or changes in referral patterns or prescribing patterns. And we're going to talk a little bit more about this later on in the presentation when we get into some of the examples of enforcement that has occurred. Some of the indicia of fraud for physicians and physician groups. Any arrangement that involves a relationship between a physician and a ancillary provider. So when you have relationships between physicians and labs, physicians and pharmacies, physicians and imaging companies, those tend to be highly suspect. They can be structured the right way, but it is something that the government looks at. Similarly with medical director agreements. Medical director agreements can be structured to fit within the personal services and management contract safe harbor, but they are very frequently not followed and frequently result in kickback violations. Speaker engagements, another area that can fit within a safe harbor, but frequently doesn't. Telehealth arrangements, okay, we're in an age where telemedicine shows great promise and is significant to the future of healthcare, but there are many, many telehealth arrangements out there where the telehealth environment is used for nefarious means, and there are a number of individuals, including physicians, that are in federal prison today for these suspect, or not just suspect, but basically blatantly illegal contracts. Another area where many physicians, kind of well-meaning, just kind of naive to what's going on, can be swept up in, and those are these no risk turnkey arrangements where a provider of a service, whether that be allergy testing or ultrasound or different imaging modality, comes in and says, well, we'll bring in the equipment, we'll bring in the technician, we'll even have a physician, a radiologist read the study for you, or a cardiologist interpret the study for you, and you doctor bill Medicare, and you pay us, X amount for each study that's done. That is a very common arrangement that in most cases results in problems. Out-of-network billing. Out-of-network billing, again, is not illegal, but there are things that, if not done correctly, can cause problems. A lot of folks come to me and say, well, listen, I'm out of network. The insurance company has, they have no business talking to me. And a lot of folks don't realize, even being out of network, you submitting a claim to an insurance company, you're subject to things like state insurance fraud, federal wire fraud, mail fraud, and these are the types of charges that are often brought by the federal government. So everything doesn't have to be a healthcare crime to get you in trouble. And then the last, and one of the more common things that both just regular audits from payers as well as DOJ investigations, and that's variance from a peer norm. Again, using data mining, they look at providers that are ordering a disproportionate amount of tests, or constantly or ordering very expensive drugs or name brand drugs that are a deviation from the community standard, or the peer standard, what other physicians in the same discipline are doing in their geographic area. That is another area that, again, is not necessarily fraudulent, but it's what raises the visibility of the provider in the eyes of the enforcement community. So how do you prepare to avoid regulatory issues? I mean, that's one of the things why you would come to us or other healthcare counsel to try and help you avoid these problems and avoid having to address and spend literally tens and often hundreds of thousands of dollars in legal fees defending yourself. Well, the first step is to implement sound policies and procedures across the board, both for your clinicians and for your billing folks. Staying up to date with changes in applicable law, especially changes in coding and billing requirements. So it's, Medicare, Medicaid, commercial payers are constantly changing the standards, the documentation required, the prior authorization that is required for various services, the documentation required to justify different levels of coding. You need to stay abreast of all this. And on that note, just really another misconception that many providers have, and they come to us and say, oh, well, I relied on a billing company. I really didn't know what they were doing. I hired a billing company to do everything. And although it kind of seems unfair, but ultimately providers that are billing under their provider number, their tax ID number, are responsible for the claims that are submitted on their behalf. You're essentially using, when you use a third-party billing company, they're acting as your agent. And there's no kind of advice of billing company defense that you can use. So you need to make sure that whoever you're using to do your billing, whether you're doing it in-house or using a third-party billing company, you need to make sure that they are up to date and that they're coding for you in a manner that is reflected in the medical record, that medical record supports whatever the claim is that's being submitted. Another area that a lot of folks, don't avail themselves of, and they should, and very often it's because of cost, but conduct regular self-assessments. Now, there are some requirements under federal law for you to do this. Certainly, there in areas such as HIPAA, you're required to have risk assessments done. But also, your billing and coding. On occasion, it doesn't have to be monthly or even annually, although annually would probably be a prudent approach, is to have a third-party coder look over the shoulder of your billing company, review some of the charts, act as if they were, hire somebody to come in to act as if they were an auditor coming from CMS or a commercial payer. Provide ongoing training to your clinical administrative staff. Very often we hear, that we've done this way, for 15 years and haven't changed. And you say, well, why not? Well, nobody ever told us to change. So it's not just enough for the owners of a practice or the owners of a pharmacy or the owners of a company to do these things, but everything has to be pushed down to the folks that are actually providing the care and making sure that all these any of the applicable rules or regulations need to be followed. So it's really a process of developing policies, doing self-assessments, doing education of the staff, and then maintain records. I can tell you how many, maintain good records, and not just the medical records, but maintain records of your compliance activities. This, if nothing else, it shows a good faith effort to comply with the law, and that goes a long way. And consult with a qualified healthcare counsel. And this webinar is not meant to be, a sales pitch for Frier Levitt. But you should really seek qualified counsel. A lot of folks will use counsel that aren't versed in healthcare. Healthcare is an entirely different regulatory world. I very often advise my friends that are attorneys and other colleagues that things that you can do in the general corporate environment are a federal felony in the healthcare space. So in general commerce, an individual owns a restaurant, and one of the vendors comes along and says, listen, you know what, you're really good, you're really a good customer, here's tickets to the US Open that cost $2,500, and that's fine, there's nothing illegal with that. But a sales rep from a drug company does that to a physician, and that physician is committing a crime. It's not fair, but that's the law. So on the front end, we want you to take every effort to avoid problems and have the tools available to defend yourself. But what do you do and how do you respond to an investigation? Well, first of all, stay calm. The worst thing that can be done is that you get excited and make mistakes. The other thing that goes hand in hand with that, and the folks that are going to enforce the laws and the folks that work for the DOJ or the Department of Defense are professional investigators. This is what they do for a living. So you're at a significant disadvantage. And their tactics are sometimes questionable, but absolutely legal. They will have 2 FBI agents come and knock on your door at 5:30 in the morning and begin to ask you questions. They will come to your office and they'll be very polite and be very nice and begin to ask questions. They make people feel at ease. But disclosing information without advice of counsel is never a good idea. I've very often, when clients have done this and said, well, the FBI came and I sat down and talked to them for 3 hours. And I said, well, what did you think was going to happen? Did you think at the end of the 3 hours they were going to be like, thank you very much, and we're going to leave you alone? So it's not advisable to talk to anybody from law enforcement without an attorney present. Don't volunteer information, and then don't get yourself in worse trouble by destroying evidence. You need to immediately put what's called a litigation hold on all of your documents. Okay, whatever you have when you receive a subpoena or investigative demand or the FBI shows it up at your door, you have to keep. You can't destroy them. You're just going to get yourself into worse trouble. Next thing is to gather responsive documents to subpoena or investigative demand. And again, we've seen lawyers that were not sophisticated in this give their clients bad advice. I had one client that the lawyer just said, well, you can't do anything. And they just loaded everything up into banker boxes and delivered it to DOJ. There are a lot of factors that are involved when we speak to government actors on behalf of providers. One thing is we say to them, the clients need, there's a medical practice, for example. You need to continue to see patients. You take the medical records and you're going to compromise patient care. And we push back. And the government will frequently say, okay, we'll come back. Or we need this, because they don't want to wade through all this stuff a lot of times. And we can make copies. We can ask them, what exactly do you want? What part of the record do you want? And we can simplify the process and minimize the disruption to your practice, to your business. And then in any document submission, and this is something that we do here at Frier Levitt, is that we don't just hand over documents, we provide a narrative. We want to control the message. You want to control the message when you're providing a response to a subpoena or investigative demand. You don't want the investigators to just be looking around trying to ferret out whatever they can. And very often from the specifications in a subpoena, we can tell what the government is looking for, what avenue they're pursuing. And in many cases, when we speak to the Department of Justice attorneys, lawyer to lawyer, they will tell us. They will tell us whether our client is a target, meaning that they're the ones directly under investigation, or they're a subject, which is someone that can ultimately become a target, but they're tangential to the investigation. So just as a side note on that, how does that happen? So there are many situations where the federal government is investigating a large entity, either a drug company, a lab provider, a radiology provider. These are all from real examples. And they begin their investigation of that provider. And as they gather leads, they look and they say, oh, this physician routinely referred to this radiology provider. Let's see if there's any connection. Is there any financial relationship? Is there any reason why the physician would send all of their patients to this one location? And that's how someone that may not be directly involved in the investigation or not be a direct target initially becomes involved as a subject. And in those cases, very often, depending on what the facts are for that provider, is that we will work with the department just to say, listen, our client has done nothing wrong. We understand you're investigating so-and-so, and my client can help you and provide you with information that will assist you in your investigation and assist you in being done with our clients and letting them get back to running their business or their practice. Another area that is important for people to understand, and to go into all of this is really beyond the scope of this webinar, but there are self-disclosure protocols available. The Office of the Inspector General is probably the number one, and that's one that we have used very successfully. CMS has self-disclosure protocol, as does the DOJ, and most state Medicaids and state licensing boards. In a nutshell, a self-disclosure protocol is basically like an amnesty program, where a provider that has done something wrong or may have realized that they did something wrong, made honest mistakes that could be construed as false claims, can go to the various agencies. In CMS's case, if there's a stark violation, the OIG violation of civil money penalties or anti-kickback, and DOJ for certain criminal or certain transgressions that can be either criminal or civil or both. A provider can go there and self-disclose, and because they self-disclose, are granted certain relief. So the penalties that are enforced against the individual or entity are much, much less by doing self-disclosure. And we currently have about 20 self-disclosures going on right now. We've settled probably over 80, which were all very favorable for our clients, in the sense that they were able to continue practicing without losing their license or being excluded or having Medicare revocation and paying a much, much smaller financial penalty than they could have been subjected to if the government had initiated the investigation. Some recent federal enforcement news, just to demonstrate how aggressive the government is. This is all of these things listed on this slide have happened in the last 2 weeks. Well, except for the last one, I'm sorry. The first 3 have happened in the last 2 to 3 weeks. All right. Physician and his ex-wife convicted of healthcare fraud. 3 physicians and 5 marketers charged with violation of the anti-kickback statute. A physician charged with his or her alleged role in $120 million healthcare fraud. And there was a large federal healthcare takedown of 54 defendants charged and convicted. And the quote below is from one of the FBI agents, and it typifies the position of the federal government. It says the FBI does not care about your status in life, doesn't care about your professional standing, your level of income, or your personal connections when you break the law. If you try to scam the system, if you exploit your professional license just to pad your pockets, if you mortgage your morals just to inflate your bank account, you will only find yourself in deeper debt. We are committed to protecting the public. We are intent on rooting out fraud and corruption. We are duly bound to track down and arrest anyone who's breaking off federal laws. I personally deal with the federal government almost on a daily basis, and despite what people may think about the Department of Justice based on the political environment and things that have come out in the media the past couple of years, many of these, I think most Department of Justice prosecutors and Department of Justice attorneys are very, very professional and very smart. Many of them, and a number that I've met personally, could frankly, these are Ivy League trained attorneys that have 20 plus years of trial experience that could easily be making over $1 million in private practice, or working at a fraction of that, a small fraction of that, on a government salary. And most of them do it because they are committed to an ideology to protect the healthcare system and protect the Medicare Trust Fund, protect TRICARE. So they are not to be taken lightly. They are professional and they are committed. So I just want to talk a little bit about one of the cases that's been in the public news, and it's something that we have knowledge of and have worked with over the past many years. In fact, we had advised people against some of these transactions with INSYS 6-7 years ago. The founder of INSYS, who was a billionaire, and 4 of their executives convicted of racketeering. They were convicted, sentenced to 66 months in prison. One of the doctors involved in Manhattan was sentenced to 5 years in prison for accepting bribes and kickbacks. All right, and the company itself paid a $225 million resolution, global resolution, to the federal government. So, you know, this physician and many of the other physicians that were involved in INSYS were paid via sham speaker arrangements, where they were paid to give lectures on the drug subsys, which was a fentanyl, or is a fentanyl-based sublingual spray. That was not only was it a very highly addictive drug, but it was in something called a REMS program by the FDA, and it was supposed to be used only for patients that had a cancer diagnosis, were opioid tolerant, and had breakthrough cancer pain. And physicians were paid these kickbacks through sham agreements to write for this medication off-label for a variety of maladies that had nothing to do with cancer or patients that were opioid tolerant. And many of the physicians that were convicted, most of them, you know, received, you know, at the high end, I think $200,000. But I think the average was about $80,000 to $100,000 in bribes, which may sound like a lot of money, but I can tell you that their legal fees alone to defend them in the criminal case was a multiple of that, and they'll lose their license in their career over, you know, $120,000 in kickbacks. And again, you know, this is something that if you're going to get involved in any type of speaker arrangement, consulting arrangement, even with big companies, I have clients that come to me and say, "Oh, here's this contract that I got, and it was written by this big law firm, and it was, you know, the drug company is you know, a big publicly traded drug company, so it must be okay." That's not the case. Well, that's not always the case. You need to protect yourselves. And with that, I will end the presentation and take any questions.
All right, so we received a couple questions. Our first one is, do you have a website that we can find the excluded provider list? This was from the ramifications for violations page.
Sure, that's we can send that out, but it's you can find it by going on the Office of Inspector General website. If you just Google HHS-OIG, it'll take you to the OIG's website, and there's a direct link to the excluded providers database, where you can, and on that database you can look up individuals or entities and see if they're excluded from federal healthcare programs.
Perfect. All right, our second question is there a statute of limitation for the government to come after a healthcare provider?
Sure. There are a variety of different statute of limitations, and it's an analysis that has to be done depending on a variety of factors. But the typical statute of limitations, or the most commonly applied, is 7 years. But there are where there is a true indicia of fraud, they can go even further in their investigation. So there are some rules that apply to Medicare of how long you have to keep Medicare claims information and medical records, so that if Medicare reopens, so Medicare also has a separate kind of non-criminal statute of limitations, which is that they can reopen a claim within 1 year of the payment on their own, or within 4 years with what is defined as a defined term called good cause shown, where there is some reason for them to believe that that there was a problem with the billing. But 7 years is really kind of the number that everybody uses as the federal statute of limitations.
All right, thank you. We have another question. What to do with regulatory issues in a relationship to medical practice retirement, with the understanding that the medical practice has always been in good standing?
I'm sorry, can you read that again? I didn't quite understand it.
Sure thing. It's what do you do with regulatory issues in the relationship from the medical practice retirement? And that's with the understanding that medical practices has always been in good standing. So just with regulatory issues and medical practice retirements.
I guess the question is that if a medical practice or a clinician has been in good standing and has retired, so the practice has closed, what is the exposure or the ramifications there? What should they do?
Right.
And so it's important to know that as a licensee, particularly in the physician practice space, is that when a physician retires, there's still an obligation to those patients. Now, there are different ways to wind down a practice. In most cases, our recommendation, and the best way to do it, and this applies to other healthcare providers, is that if you sell to another licensee. So if you're a physician that's been in good standing and now you're retiring, is to either sell or transfer your medical records and patient responsibility to another provider. And that's done, and we work with clients to do that. And that's done through a variety of techniques, including providing the appropriate type of notification to the patients, timely notifications, giving them an opportunity to find other providers, giving them an opportunity to have their records sent somewhere else. And then once that is done, I guess the other part of the question is what exposure do you have after one is retired, and that exposure obviously becomes less over time. And generally, if you've always been in good standing and the practice is wound down and patients are transferred to other practices, in accordance with state law, there's probably not a lot of liability, but it would still be prudent to keep some type of record of what you did in the past. Just kind of like, it's not dissimilar to, you have a business and you sell that business, you still have to keep the tax returns for a certain number of years after that in case you're subjected to an audit.
All right, well, thank you all for your questions. If we didn't have the time to get to them, we'll send over the questions to John to follow up with you. So this concludes our webinar. If you have any more questions, feel free to reach out to John Morrone. Here's his contact information. I wanted to thank you all for joining us today for our webinar, Government Enforcement Actions, How to Respond and How to Prepare, co-sponsored by Frier Levitt and PRI. I hope you have a great rest of your day. All right. Goodbye.